team one, they said the secretariat can nominate without consent, and the other, they said no, they cannot nominate without the consent. So if you have a dispute between two countries, we will find this debate, consent or no consent. The problem is who will decide. Let's suppose that the panel is established. If the panel is established, we move to step 4. And step 4 is related to the terms of reference of the panel. Terms of reference. The terms of reference under the protocol are the following. The panel is invited to examine in the light of the relevant provisions of the agreement cited by the parties to the dispute, the matter referred to the dispute settlement body, and to make findings and assist the DSB in making the recommendation or in giving ruling. So the panel is requested to decide on the matter, on the dispute. And the panel must address the relevant provisions in the agreement quoted by the parties in the dispute. So the terms of reference of the panel is clear to decide on the dispute. If you have a dispute related to the violation of the national treatment or of the commitment, or the panel must decide on it. The terms of reference must be made by the panel, but sometimes not by the panel. So we have a process before the panel in order that the panel get the information, the argument of the parties to decide on the matter. And the panel is requested to make objective assessment of the fact of the case and of the conformity of the measure, contested measure with the agreement. Normally, the panel must decide on the case within 5 months. Sometimes, in exceptional circumstances, the panel can take 9 months to decide on the issue. Okay, the panel takes 5 or 9 months to decide. Then step number 5 is the report of the panel. The 3 members will write their report. First, according to the protocol, the report of the panel must be drafted in the absence of the parties to the dispute. The panel must provide one report reflecting the views of the majority of its members. The deliberation of the panels must be confidential. So the 3 members or the 5 members, depending on the parties that are in dispute, they will listen to the parties, to the argument, to the information, to the evidence, and they will decide. If there is agreement between the 3 members or for the 5 members, it's okay. If not, it's by the majority, 2 against 1, or 3 against 2, or 4 against 1, if you have a panel with 5 members. That's clear. There is a distinction to understand between many categories of report. We have the draft report, the interim report, and the final report. I will try to explain to you what is the difference between the different kinds of reports. First, the panel must issue a draft report, and the draft report provides a description of facts and argument of the dispute. We find in the draft report only the fact and the position of the parties, no decision. So the panel prepares this draft report, fact and argument. Then the panel submits. Could you please come here, because they are very small, the presentations, and I have a problem too. Could you help me and come here to make them bigger, please? If not, it's okay. It's very small, and could you make them?
No.
You cannot.
Program. This program, the way it is, you're supposed to.
Okay, no problem. I will deal with that. Yes. So the panel will prepare a draft report. Then the draft report must be submitted to the parties in order to give their comment. So the panel prepares the draft report and submits it to the parties and asks the parties to make any comment within a period indicated by the panel. Then, this is the draft report, facts and argument. Then, the panel take into consideration the comment, receive it, and will issue what we call the interim report. The interim report, could you make it bigger? Thank you. Page. Which page? That's better. Here. Yes. So, the interim report includes the fact, the position, and the findings and conclusion of the panel. Then, this interim report must be submitted to the parties for comment. And at the request of any party to the dispute, the panel shall hold meeting with the parties to the dispute in order to review some specific aspect of the interim report. Then the panel will take into consideration the comment of the parties on the interim report, will issue the final report. The final report is supposed to take into consideration the comment of the parties on anything indicated in the report. Sometimes the parties make comments, sometimes they don't make comments. In practice, the losing party makes all the time comments. The party that wins is happy. The parties that lose make comments. That's logical. We can expect that. Then we have the final report. So we have three kinds of report. Draft reports, only fact with position. Interim report. This is a very good process because I know as arbitrator, some arbitrator did not decide on all the issues. And some of them, if the issues is difficult, they ignore it. Or even if they don't indicate it in the position of the parties. So at least here, we have a debate between the parties and the panel to be sure that all the issues are decided. And the point of view of the party is taken into consideration. You have three. We don't have this process before our jurisdiction or in international arbitration. Because in international arbitration, we don't have such kind of decision. The arbitrator or the judge listen to the parties, get their submissions, then the judge decides on the matter in a final decision. Here we have a process in which we have draft report, interim report, a final report. In order to issue the final report, a debate between the parties and the panel. Our report, final report, is issued. That's wonderful. That's nice. We can move to step number 6. And the step number 6 is the adoption of the final report. Step by step. "60 days. So the report is circulated to the state parties. It is adopted unless a party to the dispute formally notifies the dispute settlement body of its decision to make an appeal, or if the report is adopted, except if the party, who is the party? The losing party. Normally he's not happy, or he will make appeal. The report is adopted unless a party decides to go before the appeal mechanism, or if the TSB decides by consensus not to adopt the report. If all the members of the dispute settlement body decide to reject the report. This scenario is not practicable, but the party, because the parties that wins will vote for the adoption of the report. So the report is not adopted, is adopted except if there is an appeal or if all the members of the dispute settlement body vote against it, which is a scenario that is not practicable, because at least the party that wins will vote for the report, for adoption of the report. But sometimes the parties that win is not happy. I don't know, but that's the rules. I am not here to, I just draw your attention on a provision, and that's enough. Okay, so the report is adopted unless there is appeal. Step 7, the appeal. We have the panel, but we have the EB, the appellate body. Like in the World Trade Organization, we have a system of appeal, of control, of review. So the report issued by panel could be challenged before the EB. The EB is composed of 7 persons, 3 of whom serve on any one case. Who appoint the members of the EB? DSB, Dispute Settlement Body, will appoint the 7 members. Here we have a good solution, clear solution, that we don't have regarding the panel. If there is no agreement between the DSB members on the members of the panel, within 2 months from the vacancy, the chairperson of the DSB, in consultation with the Secretariat, will nominate the members. We don't need the consent of the state. Here is good, wonderful. We don't have the ambiguity that we had regarding the nomination of the panel members. So if the dispute settlement body agrees on the 7 members, it's okay. If there is no agreement, the chairperson of the DSB, in consultation with the Secretariat, will nominate the members that are missing. And here, this provision is very good. Why? It's better than what we find in the World Trade Organization system. You see, if it is good, I say that is good. If it is bad, I say that is bad. Here is good. I like it. I like it. Thank you, the negotiator, for this. That's wonderful. I really enjoyed it. Why? Because in the World Trade Organization, we have another system. The EB, the appellate body of the World Trade Organization, must be nominated by the states. What United States did? United States blocked the nomination of the members of the appeal organ. The United States said that the EB has exceeded its mandate and created rules instead of only interpreting them. So now the system of the World Trade System is useless. Why? Because the United States objected to the nomination of the members of the EB organ. The negotiator of the African Protocol, taking into consideration this sad reality, to avoid such scenario, they decide if there is an agreement between the state, yes, it's okay, we have the members of the EB. If not, the members will be nominated by the chairperson. Better than the World Trade Organization system. Better. Because in the World Trade Organization system, United States blocked all the candidates, blocked the nomination of the members of the appeal organ. So we don't have today in the World Trade Organization an organ of appeal body. We don't have. Because of the United States. One state. They said, no, this member is not good. No. And the United States blocked the nomination of the members, not because the candidates are not good or they don't have the knowledge or the competence, because the last member exceeded their mandate. Created rules instead of interpreting them. Creating rules and not interpreting them. United States considered that the dispute settlement, its mandate is interpretation, not creation of the rules. So here, within the context of the African continental trade agreement, we cannot face this scenario. Because the nomination of the EB members is clear. States, if not, the chairperson will nominate. So if the state is not happy with the report, the state can challenge the report before the EB. One of the issues that we should understand is what is the scope of the appeal. The appeal must be limited to issue of only law, to legal issues. The appeal deals with legal issues covered in the panel report and legal interpretation developed by the panel. So the state is not happy. The state decided to challenge the report before the EB, the appeal body. Normally, the appeal body must decide on the appeal within 60 days or 90 days in exceptional circumstances. And the EB can confirm, modify, or reverse the legal finding and conclusion of the panel. Then the EB will produce a report reflecting the views of the majority of its members. So now we have the last word on the issue is the decision issued by the EB. This decision is adopted except if all the members decide not to adopt it. It's good that we have a challenge. 2 rounds. So you see that we have many steps, report, draft report, interim report, final report. Then we have, even if, the possibility to challenge before the EB. So that is the system. That is the mechanism. Step by step, I try to explain it to you from the beginning to the last decision. I mean the decision rendered by the EB. Just to be complete, to completed issue regarding the proceedings and the dispute settlement, and as I told you this morning, we have the agreement, the protocol, but we have also 3 additional annexes to this protocol. What is the scope of the additional annexes to this protocol? Believe me, it was very difficult to find them. I noticed that some of you, they sent them yesterday on the groups on WhatsApp. But on the website of the Secretariat, I did not find them. We have 3 annexes. I want to explain to you the subject, the 3 annexes, what is the rules or provision provided in the 3 annexes. We have 3 annexes. The first one is Annex 1, working procedure of the panel. The submissions of the parties, the timetable, written and oral submissions. So this annex provides rule to determine the exchange of submission between the parties, 3 weeks. The claimant state has 3 weeks to submit written submission, then the other one 3 weeks to answer. Then we have a second round of exchange. Then we have oral submission. So we have, it's very short annex, not a lot of provision. So we have the provision related to the procedure before the panel. Then we have Annex 2. Annex 2 is related to the expert review groups. What does it mean? The panel may refer matters to expert. The panel may sometimes needs helps from experts, so the panel can nominate expert in order to understand the case, and the expert will help the panel to decide on the matter. Note that the expert review groups can be used by the panel, not by the EB or appeal body. EB because the appeal body are members that are experts. They are have more knowledge than the members of the panel. Then we have Annex 3, Code of Conduct for Arbitrators and Panelists. It's about independence, impartiality, and disclosure. The member of arbitrator and panelist must be independent and impartial, and if there is a conflict of interest, the members of the panel must disclose it. One of the aspects that the three annexes did not deal with is the issue of electronic filing of documents. We don't have any provision regarding this issue. And when you see today the dispute settlement mechanism, the arbitration institution, all of them, they provide rules regarding the electronic filing of document and regarding the hearing by Zoom, the hearing using electronic means. We don't have any provision regarding this matter. This brings us to the last point, to the last step in our exploration of the dispute settlement mechanism under the AFTA. Now I will give you an opportunity to ask questions, to make comments. I want to be sure that any participant here understands the process clearly from the beginning to the end, taking into consideration the different steps: consultation, mediation, establishment of the panel, term of reference, decision, appeal, and all the process. If you have the agreement with you, the protocol, the annexes, you have the possibility to get the details and the different aspects. You know, it is difficult to describe all the rules. There are some rules, there are some exceptions, but at least here we have the structure, the global structure of this dispute settlement from the beginning to the decision issued by the EB. And this issue is clear, the steps are clear, and the scope of the mechanism is clear. Please, if there is any ambiguity, don't add ambiguity to the ambiguities, please. I am very happy to deal with, so Elvis, maybe you should.
So just to inform you that now we are opening the Q&A. However, the Q&A will be limited to between 7 and 10 minutes, because if you look at the program, we are supposed to go to lunch at 12, but we're not going to lunch at 12. We're going to go to lunch at 1:10, so that Prof can finish all his sessions, and in the afternoon we will proceed with the one that's Miss Njovu and with Dr. Vela. Yeah, okay, in the afternoon. So the afternoon session that was supposed to be done by Prof. Ben Walid Hamida will be done.
Please, Walid Ben Hamida. Yeah. All the time they kill my name. Some people they said I am Ben, others they said Walid, others they said Hamida. Hamida is the name of woman, not a man. So please, in US they said Walid Ben. I am not Ben, I am Walid. This is my first name. Ben Hamida is my family name. Don't forget that. Don't forget that. Walid is my first name. Ben Hamida is my family name. I am not responsible for that. My parents select my first name, and my family name, I don't determine it. So I'm sorry for this complication. But please spell it as it was.
Bien noté, bien noté. Merci beaucoup, mon frère. Ça c'est bien noté.
No, thank you. I'm
Très
joking.
bien.
I'm joking.
Très
But
bien. Non,
you
non.
know that you
Non, je
are
comprends,
the security council. You do what you want.
Entre nous, c'est comprend. Comme on fait chez nous. Okay, so we have already the candidates.
Thank you so much, Professor. I think it is clear now that with regards to the dispute settlement, it has to be state parties and not private companies or individuals. So my question is, in an event that there is an infringement or a violation of the agreement itself, and it involves a private company, and of course it has to be the state now that has to submit the dispute. Now, in a situation where the state is not desirous to pursue the dispute on behalf of that private company, probably because of political reasons and all those things, are there any remedies that are available to the private company to push the state to submit the dispute under this framework? And then just an additional one, I also want to find out what is the role of national courts. I know that in our midst we have respected judges, so does this framework give something to our judges to be actively involved, because they resolve various kind of dispute, and I think a perusal of this agreement reveals that they are not catered for. I submit.
The first question, I will deal with it my next presentation. My next presentation will be dedicated to the access. Okay, three, then I answer to the three together. Okay.
I just wanted to inquire whether from the procedures, whether that poses any sort of barriers for even states to participate in it, because obviously we've established that it's not been working for the WTO. So are there maybe procedural requirements that are impediments for African countries to participate in that dispute settlement mechanism?
Yes, sorry, I'd stepped out a bit for the latter part of the presentation, but I had this question from the beginning. In terms of solution design, there's something Dr. Rono mentioned when she was talking about non-tariff barriers during her presentation. I think it was either yesterday or the day before that. She mentioned about the settlement system. And the question is whether some aspects of that can be used to supplement the dispute resolution process, to the extent that African countries are very non-litigious. You had mentioned yourself that to date, only 4, I think, countries have been parties to disputes at the WTO DSM, and only 2 of them as initiators.
Yeah, Tunisia and Morocco. Tunisia and South Africa.
Yes, whereas 40 are parties to the WTO agreement. At the same time, we've had the dispute settlement protocol for 25 years now, and we still haven't had a case taken to it. So it would seem we are a generally non-litigious people, but at the same time we still have to have mechanisms to sort that out. And the non-tariff measures, because there's under Annex 5, the NTB Annex, there's that specific set of measures. There's the reporting, and then there's the facilitation, and then there's the elimination. So possibly for tariff issues, they would still need to go, but for the smaller so-called violations, nullifications and such that wouldn't qualify as tariff changes, could they be solved through that mechanism?
Okay. Regarding to the access to the mechanism to the private actors, I will deal with this issue in my next presentation. Your question is very, very good. So please, if you don't get the answer that you look for, don't hesitate to ask me the same question. Regarding your second question related to the role of the state court, the agreement and the annex and the different annexes, additional annexes, did not provide for any role for the state court. So the state court have nothing to do according to the protocol. The mechanism is administered by the dispute settlement body. However, there is a question, because there is a provision that I did not mention. According to the protocol, the states can use arbitration to settle their disputes. So two states can decide to settle their disputes by arbitration. They nominate arbitrator and they will decide their dispute using arbitration. And the arbitral awards will be rendered by the arbitral tribunal. Some people raise the issue how to deal with this arbitral award and how to deal with arbitration if the parties, the state parties, the two, or more than two, decided to use arbitration to settle their dispute. We don't have a lot of provisions related to this situation. Here, if the parties decided to use arbitration, the question is, we know that in arbitration, the state court can play a role, can be involved in the process. For what? For preliminary measures and for the enforcement. The award could be enforced before the state court. So here I don't have the answer to this issue. In the interest of the system, I don't think that the intervention of the state court is good for the system, because we have many courts and each court can decide on this matter taking into consideration its own rules and proceedings. For the interest of the system, it's better to get a centralized system, not a decentralized system, depending on the different position of the different court and jurisdiction. There is one issue in the World Trade Organization. Sometimes the state violates the World Trade Organization agreement. Then companies, they went before the state courts of the state that violates the World Trade Organization agreement, and there are some decisions rendered by the dispute settlement body against them. Some companies take the decision rendered by the dispute settlement and they try to use them before the state court. I explain. I am a company, I was victim of discrimination. The state, there is a dispute settlement that was initiated and the World Trade Organization dispute settlement issued a decision against the state. And in this decision, the dispute settlement decided that the state violates the discrimination rule. I am a company, I am discriminated. Can I invoke this decision rendered by the dispute settlement before the state court? Can give you an example to make issue easy. For example, I am a French company. I was discriminated in the United States. And France or the European Union initiate an action before the dispute body of the World Trade Organization. The dispute settlement body decided that United States, violates the discrimination rules in the World Trade Organization agreement. As a company, can I invoke this decision before the state, the US state court? I will ask the state court to protect my rights, and I will say I am a company, I was a victim of a discrimination issued by the United States. Can I invoke that before the state court? The answer is not. Why? Because many countries, including the United States and the European Union, they consider that the World Trade Organization provisions are not self-executing. We cannot invoke them before the judges, before the court. They are invocable only on the relation state to state. So this is a very interesting issue. The state court and the dispute settlement mechanism. Not not only the dispute settlement mechanism, but all the agreement, the African agreement. If some of you want to make a PhD, it could be a challenging and interesting issue to see. We have a system of norms, we have new rules that affect private parties. Mainly, the trade measures affects companies, not states. Directly, they affect the economic operators. To see if the judge, if the court system can be involved in this process, including the dispute settlement procedure. There is another question, I forget it, about what? About, the second question was about what? About... the procedure look natural, so the mechanism could be used by each country. But you know that the problem, some countries, they have the knowledge, they have the experience, others they don't have. And as it was said, Africans, I will mention it in my next presentation, they don't use dispute settlement. In the World Trade system, we have only 4 states that use it, the dispute settlement mechanism. I think Tunisia, Morocco, and South Africa, and I forget I will mention it later. And we have a case between Tunisia and Morocco before the dispute settlement mechanism. 4 states, and we have 40 African members. So African, they don't use the dispute settlement mechanism. For different reasons. Sometimes they don't have the knowledge, sometimes they don't have the ability, sometimes they don't want to pay. Because if you want to use the World Trade Organization mechanism, you have to pay for lawyers. In Geneva, there are some law firms that offer their services, and you need to pay for them. You need to pay to be presented. This procedure, to finish with last comment, is the general mechanism. There are some specific mechanism, procedural rules. So you know in law that the special prevails on the general. What I try to explain is the general process, but sometimes you have some specific rules depending of the area, and in this situation we have to give priority to the specific rules. So there is another issue, is the general and the special. Here what I did with you is to present the general mechanism, but I cannot go topics by topics to explain to you what is the procedural mechanism that can be used. So the procedural mechanism that can be used is this. However, sometimes we have some area, as we said, where we have special rules. In this situation, we should take into consideration the special rules, and in law, the special prevails on the general. This brings me to the end of the first topics. And as I told you, the first topic is to explain to you the mechanism. We have 2 more topics. I will try to deal with them quickly before the lunch. The second issue is related to a point that was mentioned by our friend, is the problem of access to the dispute settlement mechanism. And here I will go directly to the key points. We have 2 issues to deal with. The first issue is access of private actors. That's what we mentioned. The second issue is access to the other mechanism available. Because this system is not alone. We have other available systems of dispute settlement that could be used, that are available. So the question is how to articulate, coordinate this mechanism under the African Continental Agreement and other available mechanisms that I will list. So we will try together to explore the two issues one by one. First, access of private actors. As you said, the private parties cannot bring action before the dispute settlement body. However, some regional economic communities in Africa, like the Treaty for the Establishment of the East African Community, give private actors the right to bring action before, for example, the East Africa Court of Justice. The Commissaire Treaty, under Article 22, give natural and legal person the right to go before the Commissaire Court of Justice. If you are an economic actor and you are covered by the East African Community Treaty or the Commissaire Treaty, you have the right to bring action before the court. In the same time, the state has the right to use the African dispute settlement system. Let me start by private actor access. The exclusion of these non-state actors was criticized by some people, but the World Trade Organization is state to state also. They said, it's not me, that the mechanism is state-centric. Because non-state actors are the majority of traders in Africa. Trade disputes involves exporters, importers, company, normally, who faces the violation? The company, the operator. Who faces the taxes? The private actors. Who faces the discrimination? Who is affected? It's not the state, it's the private actors of the state. Who to initiate an action for a private actor? You said you have to go and ask your government to initiate the proceedings on your behalf. What's happened if the state refuses? In the World Trade Organization system, in some countries like Switzerland, if the state refuses, you can initiate an action before the state court to force the state to defend you. Swiss, they have the right to be protected by the Confederation, even if traders. So in some countries, we can, if the state refuses to protect you without any reason, we can force it to use the system to defend you. I don't know if such mechanism could be used in Africa. And then the problem is, even if the state will use the mechanism, the private party is not technically and legally parties of the proceedings, because the proceeding is state to state. maybe the state can invite him to present evidence to maybe, but however, to be very neutral, it's very dangerous to open the mechanism to the private parties. I understand that the private parties are affected, but if you open the mechanism to the companies, all of them, they will challenge the measures, so it will be very difficult to manage. Maybe we have to find a creative mechanism, like kind of committee that selects the private actions that could be decided and private actions that cannot be decided, but opening the mechanism to the private actors could be very, very dangerous, because we have the experience of dispute settlement in investment between the state and the investor, and many arbitration initiated just against the state, they are abusive. So normally it's the state that can use the mechanism. So if you have a private actor, you have to convince your state to use the mechanism to protect your rights. But there is another problem, because the private actors have not the same power. The big companies, maybe they can convince the government easily than the small companies. So another problem is the scope of the dispute settlement body is the agreement, the African Continental Trade Agreement. There are some issues like human rights, and in some African regional economic communities, we have provision related to human rights. So sometimes we have a trade dispute, but in addition to the trade disputes, we have a human rights dispute. For example, the East African Court of Justice has jurisdiction that is expanded a little bit, because it's not only a judge for trade disputes, but only human rights issues. And sometimes the same measures violates the trade rules and the human rights rules. But here, you can imagine, so the government will initiate action before the dispute settlement body for the trade issue, for the trade violation. However, the private actor, can he initiate a dispute before the East African Court for the human right rule? Because a measure can violate two kinds of rules: the trade rule, but the human right rules. So it's a question that I am raising. I don't have the answer. Then the second problem, and the two problems are connected, is the problem of overlapping jurisdiction and forum shopping. What is the problem? I mentioned it. The African Union recognized 9 major regional economic communities. The Common Market for Eastern and Southern Africa, the Arab Maghreb Union, the East African Community, the Economic Community of West African States, the Intergovernmental Authority on Development, the South, many. And many of them, they have their own dispute settlement. Also, the African countries are members of the World Trade Organization, and the World Trade Organization has its own dispute settlement system. How to coordinate them? Just before answering to this question, how to coordinate, as mentioned, the African countries, they don't want dispute settlement. 44 African are members of the World Trade Organization, and the 4 countries that use the system, South Africa, Egypt, Morocco, and Tunisia. 3 are from North Africa. So you understand that North African, they like disputes more than sub-African countries. You understand why I am source of disputes. You are more litigious than the others, I think. 3 countries from, and only 2 initiated a dispute before the World Trade Organization, South Africa and Tunisia. Tunisia initiated a dispute against Morocco. Why African, they don't use dispute settlement in general, dispute settlement mechanism? Lack of expertise, cost of application, political reason, lack of trust of the mechanism. Sometimes they don't trust the mechanism. They said it's not useful, this mechanism. Limited market share, small. Then even if they win the case, they know that their capacity to retaliate is limited. So you have to think about all these factors. Okay, the problem of overlapping jurisdiction. We have the solution in Article 34 of the protocol. What this provision provides for a state party which has invoked the rule and procedure of this protocol with regard to a specific matter. Please, allow me, I don't understand what is a specific matter. Then, shall not invoke another forum for dispute settlement on the same matter. On the same matter. So the rule here is that if you invoke the protocol, the dispute settlement mechanism of the protocol, we cannot use another dispute settlement for the same matter. That is the rule. It's clear. If a country uses the African dispute settlement mechanism, the country cannot use another available mechanism. Is it okay? Is it clear? That's what Article 34 said. If the country invoked the rule and procedure of this protocol on dispute settlement regarding a specific matter and the same matter, we cannot use another mechanism. Example, if Tunisia and Morocco, they have a dispute. Tunisia initiated action before the dispute settlement mechanism of the AFTA. Tunisia cannot invoke another dispute settlement mechanism to settle the same matter. That's the rule. If you use the African system, you cannot use another World Trade Organization system or any other mechanism provided under the regional economic communities. Good. However, the protocol did not answer to the other scenario if the state start by using the dispute settlement. So if we start by the African, you can't use another. But if you start by the other dispute settlement, can you use the African system? Not clear. The protocol did not say any words on the reverse scenario where parties initiate or activate the dispute settlement mechanism after activating another available dispute settlement mechanism under another agreement. What we have is state party which has invoked the rule and procedural of this protocol with regard to a specific matter shall not invoke another form for dispute settlement on the same matter. If you use the African system, you cannot use the other mechanism. But if you use the other mechanism, can you use the African system? More important, what's happened if the claimant state decided to use the dispute settlement mechanism under the protocol and the other state decided to use the World Trade Organization system or another system. Tunisia and Morocco. Tunisia initiated action before the African Dispute Settlement. Morocco goes before the World Trade Organization. How should we coordinate these parallel actions? I don't have the answer. Then there is a problem to determine what is the specific matter and what is the same matter. As I told you, some dispute mechanism covers trade and human rights. So if the states initiate action for the trade measures and the trade rules, what about the other issues, the other rules, the other obligation could be submitted to the other mechanism that is or that has jurisdiction? Does this dispute, because the dispute is linked to rules, and the rules are not the same. We have sometimes we have a measure that violates the trade rules but other rules. And the other rules, like human rights rules, we don't find them in the African continent AFTA. We don't find them. We find them in other agreements. So we have some problems, mainly on the issue of coordination of dispute settlement mechanism, because we have other dispute mechanism available under other trade agreement. Some of them are open to the private actors, and we have now new mechanism, state to state. We know that if you use the African mechanism, you cannot use the others. But if you use the others, can you use the African? I don't know. I don't have an answer. I will finish the third problem, and then I will give you the floor for question and comment. Last issue is enforcement. So let's suppose that we have our decision how to enforce it. The principle is that the parties, the state party, must observe the recommendation and the ruling of the dispute settlement body. The principle is that enforcement will be the consequence of the decision. That means if the measure is considered as violating the agreement, the state will revoke this measure. If there is a discrimination, the state must stop this discrimination. That means the state must modify its rules, its practice, the measure. And the state party, losing the case, must inform the dispute settlement body of its intention in respect to the implementation of the recommendation and ruling of the DSB. The state has 30 days to, after the adoption of the report of the panel or of the EB, to explain how the report will be enforced. 30 days. But there are some problems. Sometimes the state said, I observe it. The other that, no, we don't observe. So there is sometimes a problem on the implementation. The state argues that it observed the decision. The others said, no, it's not the good implementation. So sometimes we have a dispute on the implementation, if the implementation is appropriate or not. So if there is a problem on the interpretation, this problem must be submitted to the panel or to the EB. Then, the protocol provides that the state can ask for a reasonable period in which to enforce. And there is a period that is determined, so the state can ask for a period to implement 45 days. Then, if there is no agreement on the period, they have to nominate an arbitrator that will decide what is the reasonable period for implementation. If there is a disagreement on implementation, as I told you, the matter must be submitted to the original panel. If 90 days to decide, so if there is a dispute on the implementation, the matter must be decided to dispute settlement procedure, including, if possible, the original panel that will decide if the implementation is conform or not. He has 90 days to decide on the implementation. If not, if there is no implementation, the state can ask for compensation and suspension of concession as a sanction. The state can ask the dispute settlement body to compensation or suspension of concession. We start by the same sector. If not, we can go to another sector. If not, we can go to another provision or obligation of the agreement. And the suspension of concession must be equivalent to the level of the nullification or impairment. Look here, they use the World Trade Organization words. I don't want to deal with this case. I have a case, well, maybe I will do it to be sure if you understand or not. So we have country E imposes taxes that are discriminatory. On import of sugar, the same case, from country B. Country E and B are members of World Trade Organization, COMISA, and African Continental Trade Agreement. We are invited to decide which dispute mechanism could be used and what is the best choice for B to protect its rights. What do you think? We have 3 mechanisms that are available. We don't have time. I asked ChatGPT to give me the decision. So ChatGPT was intelligent. He said, yes, country B could bring the dispute under World Trade Organization dispute settlement mechanism, COMISA Court of Justice, and the African Dispute Settlement Mechanism. He said that he's stupid. The World Trade System is the most effective and reliable. Why? Because he has developed jurisprudence, binding enforcement mechanism, and clear rules on discrimination and quantitative restrictions. He mentions the arguments. He said that you can invoke Article 3, national treatment, restriction, quantitative restriction, jurisprudence that is highly developed, binding ruling, retaliation mechanism. Disadvantage, the appellate body is not working since 2019. This is the disadvantage. We have not the right to make appeal, to challenge. Then dispute settlement under COMISA, you can use the Court of Justice, COMISA Court of Justice. The measure could violate the non-discrimination within the COMISA and the rules on free movement of goods and elimination of quantitative restriction. The advantage, you have a regional court with jurisdiction over treaty violation. Decisions are legally binding. The disadvantage is limited case law compared with the World Trade Organization and less experience with complex trade disputes. We have also the third option, the AFTA mechanism, but ChatGPT said, very new system, and you have no jurisprudence. So be careful. If you start by using the dispute settlement under the AFTA, we cannot use the others. That's what the protocol said. Just to finish, time is important, and you have to finish quickly this long presentation. I'm so sorry, really, because you support me for a long time. Yesterday you supported me for 1 hour, today for 3 hours, 4 hours. Some they like me, others not, others they are natural. Time is, don't forget that this coexistence together is limited. So you imagine, if you hate me, some people are forced to live with me. So your situation is really very good compared to the other. How much the mechanism takes? If 22, 23 months for the dispute settlement mechanism and for the enforcement. 23, it's about 2 years. If there is an appeal, the process will take between 25 and 26 months. The enforcement process, that means if you have a decision from the panel or from the EB, the enforcement process takes up to 15 months. So that's the time. In order to get the decision, and if you include the period of the investment, if there is no appeal, it takes 23 months. If there is appeal, it takes between 25 and 26 months. The appeal, if requested, takes 2 to 3 months. And the enforcement, in both scenarios, with appeal or without appeal, the enforcement process takes 15 months. About 2 years minimum to get the decision. And this brings me to the end of this session. Thank you for listening. I know some of them, but we stay united, African, we stayed united, and we have the same goal, the same purpose is to make our instrument, our system good. And it's an important evolution. You have to recognize that is an important evolution, and I hope that the mechanism will work as it indicated in the treaties, in the agreement.
Thank you for the presentation. I just want to go back to your last example of country B, which ChatGPT took away our opportunity to answer that one. Looking at the choices, one of the things that would inform country B, more than what we saw there, will be if there is any other rights that have been violated, like the human rights that you said, so that it can actually choose a forum that will actually take into account that. And then also, time is of the essence. Country B could also look at the time in which this whole dispute can be resolved. Thank you.
Okay, wait for 2 more questions.
Yes.
Switch off the mic first.
Even if 4, I don't have a problem.
Go ahead. Okay, you're off the mic.
Okay, thank you, Professor. I don't know if I'm allowed to ask a question from the previous presentation. Am I allowed? Okay. I'm just wondering whether this process of seeking comments from the state parties on the interim report is useful or beneficial, because I'm wondering whether, is it not maybe opening a can of worms for state parties to re-argue the case, bring in new issues, and can we even review the interim report? And I really want to know, what is the purpose of that step? Is it really necessary to have that step in the process?
Thank you. The third question?
Okay, so my questions are in two folds, and I may need an answer to the first one to be able to know whether to answer ask the second question. So the first one is whether the decisions that are made by AFTA, whether they are binding. I would think that they are binding in terms of when the determination is made. And so if that is the case, and there was something that you raised about which of the, whether you would use COMESA or AFTA or WTO, whether if you bring, let's say, the same set of facts before AFTA, then that means that you can't go before, let's say, the WTO. But then the agreement has not specifically said that when you go to WTO, you cannot, like basically the reverse. However, I'm just thinking that based on international law, in terms of the law with regards to res judicata, if it is really the same set of facts, I don't think any panel or judge or any lawyer will think that they can go to another forum, raise the same set of facts. So it's neither here nor there, whether we decided not to state it. I think if the same set of facts is argued in one, you can't possibly send it to another court, and we as lawyers can raise that. And aside that as well, there was the last comment. Aside that as well, with what you said about the human rights, there being a fused, let's say, human rights issue, and then let's say there being an issue with regards to the agreement in itself, you could decide that maybe for AFTA, you would send something based on the agreement. And then when it comes to, let's say, the human rights, you could make that, you could separate the two and say that, well, this has been dealt with. And so with something like that, you can take it before another forum and you should be fine. So I don't think it's an issue.
ChatGPT did not take into consideration the human rights issue, but regarding the issue of disputes, it's very complicated issues. The similarity of the dispute, how to determine it. According to public international law, even if the rule is similar, it does not mean that the interpretation of a similar rule will be the same in the context of different agreement, because the agreement has not the same objective. So I understand from legal point of view that if you have the same rule, there is the issue of res judicata. However, according to International Court of Justice, a provision that is similar that we find in two treaties, this does not mean that the interpretation must be similar. Why? Because when you interpret a provision, you have to take into consideration the objective and the context of the treaty. And the objective and the context of the treaty is not the same. First. Second, some treaties provides for similar rules, but in addition to the similar rules, we can find other rules that are not provided in the first treaty. So we have provision to discrimination and the provision related to discrimination in the AFTA. On their face, they're looking the same, but they are not the same because the exceptions are not the same. The conditions are not the same. So if you violate the World Trade Organization agreement, the discrimination rule, that does not mean that we violate the discrimination rules under the AFTA. They are not the same, even if we have non-discrimination. And sometimes we have rules that are available in the Trade Organization agreement or another regional agreement that are not available in the African agreement. So I understand the principle of res judicata. A dispute could not be settled 2 times by 2 different judges. But how to determine the res judicata? That's the first issue. The second issue is what's happened if one state decides to go before the African system and another to go before the World Trade Organization system or any other system. In this scenario, we don't have a decision already rendered by the mechanism. This situation is more problematic than the first. Or sometimes the state is not happy during the process, they will go to another mechanism. But I understand the reason. I understand, but it's, res judicata is a big problem. There are many PhD. What is res judicata? In investment context, they said that if 2 states, they have an investment treaty and they have a regional treaty, the investor can use both agreements. Why? Because they said that even if the provision is similar, its interpretation cannot be similar because the objective, the context of both treaties is not similar. So one of the problems is how to determine the identity of the dispute. How? The facts are the same, or the rules that are violated are the same, or both. We know the res judicata principle in the domestic context, but how this concept will be interpreted in international if the facts are the same? What does it mean the facts are the same? We have the same measure that is discriminatory. We have to look to the legal issues or not. Then I can go further and I will tell you some regional agreement, they are open to the private person. So a dispute between a private person and the state is not similar to a dispute between 2 states. The parties are different. And you know that for res judicata reasoning, one of the conditions is that the party must be the same. So it's not so easy, as you explained, for me at least. Yes. Yeah.
So, with the res judicata, what I'm explaining is that you are not looking at the facts that the set of facts are alone, or you're not looking at the fact that there's COMESA, and COMESA is talking about discrimination and WTO is talking about discrimination. That is not what res judicata will be talking about. They will be looking at the context of what issue has been decided on.
How to determine it?
How to determine whether it's the same set of issues that has been decided on. So regardless of whether it is, depending on whether they give an interpretation of what discrimination is under the WTO and give an interpretation of what discrimination is, let's say under COMESA, when they look at what decision has been made, that is how they'll be able to decide the ratio. And when you decide the ratio and you realize that a determination has been made on an issue, it could be that the interpretation would have been made, but if a determination has been made on the same issue,
yeah, that's the problem.
Then
how do the determination is made according to rule of law. So if you interpret the COMESA rules in a manner, I can argue that this dispute was settled under the COMESA rules and interpretation. And the fact that, or if you have the same rule, that does not mean that this rule will be interpreted in the same manner. So this is a very difficult issue to determine the identity of the dispute. I understand your argument.
No, I think you are misunderstanding me, because my issue is not that they'll be making an interpretation. My issue is that what would have been decided.
Yeah, determination. But
what would have had been decided would be the same thing. So I'm not talking about how they make the interpretation. They could interpret whatever that COMESA is. They could interpret whatever that is in WTO or after. But the question would be what has been decided, not the interpretation process.
But what is decided is based on laws. We are making decision based on laws, on provisions. So it is very difficult. I understand the conclusion. In order to understand the conclusion, you need to understand the basis of the conclusion. So they said the state issues a discrimination. That's the decision, that's the conclusion. But this conclusion must be linked to the reasoning to understand it. So discrimination, yes, but discrimination in accordance to the World Trade Organization agreement. And the discrimination according to the World Trade Organization rules is not necessarily, or the measure is not necessarily a discrimination if you take into consideration a discrimination in the context of another agreement. To be clear, some measures could be discriminatory in accordance with the COMESA, but not in accordance to another agreement. They could be discriminatory too, but not sure, because what is important is not the rule or the provision, is the system, because the rule must be interpreted in the context of the system, and if the system is different, the interpretation is not necessarily the same. More than that, a measure could be considered discriminatory by the World Trade Organization system, but not within the African continental system. So I understand that, but my problem is how to determine the identity, the issue, the settled issue, how to determine it. Yes, please, last question.
Another round. Okay, Mr. Chair, you have the microphones. Those I gave the microphones already. Then I'll give another.
Thank you, Director of Programs. Professor, my question relates to enforcement, and I hold the view that the enforcement framework is not effective. More so, rather, especially when it relates to the least developing countries. What you pointed out is the only things that are available, of course, is compensation and suspension of concessions, yes. So I'll cite an example. Let's say there's a dispute between a big economy like Egypt and a small country like Comoros. You see, if a decision is passed against Egypt, I think they would care less about the implications. So for me, I would think that perhaps they could have done better, especially to protect these smaller countries. I think that's my view. Perhaps they could have maybe even adopted frameworks, let's say, for example, under the COMESA and EAC, which are very effective as they open up to private actors as opposed to state actors. Thank you.
Yeah, thank you very much. Thank you, Prof, for that clarification and enlightenment. I think one thing we are missing in the case scenario that was given here, we didn't actually say whether or not we didn't actually identify whether or not these two countries were parties to all of these agreements. Because if A is party to the WTO and B is not, then the WTO forum is not, at least it's not competent, because B will not be party to the WTO. So that's excluded. ChatGPT missed that, I think. And when it comes to choice of forum, the WTO has its own choice of forum, and it is exclusive jurisdiction. So if it's a WTO issue, you cannot pursue that elsewhere. Just so what I'm trying to say is that if the AFCFTA has its own, WTO has its own, most of these treaties have their own choice of forum clauses. So I would suspect that that problem will not necessarily materialize here as well. In terms of whether or not you can pursue the access to individuals and non-state parties to the EFCFTA. This is just a year. I think it already came out here, even yesterday. We talked about the investment protocol and the project of an ISDS, which is not yet concluded. I was just wondering, do you think it's something that is, do you want that? Because we are creating a treaty here and we are saying states do not litigate. There is a fact. We know that at the WTO, only few countries have participated as parties to the dispute, and many of them are as third parties, meaning the result did not benefit them because they were third parties. We know that. We know that they've been involved in investment disputes. Yet, in the case of the EFCFTA, they chose the state-to-state dispute mechanism. So I was just wondering whether or not we wish to have an investor dispute settlement mechanism in the case of the EFCFTA, at least for private individuals, for firms that are the victim of any type of barriers to trade and investment.
Okay, Dr. Justice Chifundo, mic testing.
Thank you. Mine is not so much a question as at the risk of reopening the can of worms, but we must discuss issues forthrightly. The earlier issue that arose about the supposed power of veto that a state party might have to the constituting of the panel, I went to the rules that actually explain on or elaborate upon what is contained in the protocol itself. And I think Article 8, Rule 7 of Annex 2, which is understanding on rules and procedures governing the settlement of disputes, I think it provides elaboration on what Article 10.7 should be implemented. And if I may just read the text, if there is no agreement on the panelists within 20 days after the date of establishment of a panel, the Director General, in consultation with the Chairman of the DSB, shall determine the composition of the panel by appointing the panelists whom the Director General considers most appropriate in accordance with any relevant special or additional rules after consulting with the parties to the dispute. And the Chairman of the DSB shall inform the members of the composition of the panel, thus formed no later than 10 days. So, to my view, I think you cannot read the requirement for consent in a manner that...
Interpretation?
Pardon?
This rule, what is the origin of this interpretation that you mentioned? Annex 2, which one? Which annex?
Annex 2, understanding of disputes. That's Annex 2 to... I thought it's Annex 2 to the protocol on... Pardon? Ah, okay. All right, okay. Yes, yes. Oh, it is the WTO. Okay. No, thank you for that clarity.
Then the issue is which terms will be applicable. Even if it is true, even if you have this in an annex, the issue is to settle the conflict between the two different rulings. Okay, imbalance, yes, we have this imbalance, even if before the World Trade Organization, Tunisia and United States, they don't have the same power. They don't have the same capacities. That's true, and in Africa, we have the same problem. You said Egypt, Nigeria, Comor Union, we have that. Everywhere, all the time you have that. Even if the domestic context, you have this problem. between big companies and the consumers, and you have that. There are some measures. I told you that for enforcement, you give them time to enforce, and we have some measures in order to take into consideration their capacities. But the problem is existent. Choice of forum. Let me start by an example. You initiated action before the dispute settlement under the African. We have a decision. Then one party decided to go to the World Trade Organization system. According to the African, you cannot do that. But this provision, we find it in an African treaty that is applicable on the African states, not on the World Trade not on the World Trade Organization system. So if the panel in the African context decided that the measure is discrimination or violation of the African agreement, then if the matter is referred to the World Trade Organization system, normally the protocol said that you cannot do that. But the protocol is applicable on African states, not on the World Trade Organization system. So you have to convince the World Trade System that the issue could not be litigated 2 times before the African system and the World Trade Organization system. So you have to argue that under the World Trade Organization agreement, this dispute could not be submitted to the World Trade Organization. This is not so easy. And the World Trade Organization, they can say, oh, the Africans, they decide what they want. My mandate is regarding the World Trade Organization agreement. And the same provision, I try to explain to you, the same provision, even if we have the same provision in the African agreement and the World Trade Organization agreement, that does not mean that the same provision will be understood in the same manner, because we interpret the provision, and when you interpret the provision, you take into consideration the context, the objective, and the context and the objective of the African agreement are not the context and the objective of the World Trade Organization agreement. So if I am a lawyer, I will say, yes, it was decided, but the discrimination was interpreted according to the African objectives, and the WTO, they have another objective. So the fact that we have the same provision, that does not mean that they have the same meaning. So it's a new dispute for me. And if I am intelligent, I will add another rules that was not invoked before the first mechanism, and I will say, no, we have a new disputes, because here we have an issue of discrimination, and we have an issue of quantitative restriction or any other issue, transparency, and I will create a new dispute. So, I am an arbitrator, I know the problems. And the lawyers that are very creative, they find all the time. Even if you go to the Maghreb Union dispute settlement, or if the other scenario is not clear. So if you, okay, let's take the other scenario. Let's play. You go to the Maghreb Union dispute settlement system. Then we want to go to the African system to settle the same dispute. Is there any rule in the African system that say that if you use the Maghreb system before, we cannot use the African system? We don't have it. We don't have it. Why they did not say it in the agreement? Why they opened the matter open? They let the matter open. So we think that they are easy to understand, easy to settle, but when we see the battle, the conflict, when there is a conflict, the situation becomes serious, very serious. This brings me to the end of this presentation. I want to thank you Two more questions.
Two more questions. We have passed lunch already. So those two microphones I gave, straight to the point. Thank you.
Okay, maybe just a comment on what Prof is saying. Thank you very much for the presentation. I think on matters trade, you have to be certain, first of all, how the cause of action is arising. It is trade. So you're going to look at under what system are you trading. Trading is about, a preferential agreement is about the preferences you're getting. So you're going to look at, if you're trading under COMESA, for instance, it is under that COMESA preferential arrangement that your rights have been violated, or the African AFCFTA, for instance. So that will determine where it is you're going. Because if you are going to bring in sugar based on the preferences you're getting under COMESA, then it may not serve you right to carry that particular dispute to the WTO, regardless of the fact that you're both members of the WTO. So I think when matters trade, that is how you'd have to look at it and deciding your choice of forum. And maybe perhaps just to bring a few issues to light from the earlier discussion, the mention of the DSB meetings not having been held. I can confirm that since 2021, we've had meetings. The law requires that there have to be one meeting per quarter. Those meetings have been held. Granted, there are no disputes being settled at the moment, but those meetings have been procedural in terms of trying to ensure that everything is in place. And that is how all the instruments you mentioned, the annexes, they're actually in place. The code of conduct for all the appellate bodies, the panel members, even the appellate bodies in place through meetings of the DSP. The issues of transparency, accountability, those are as regards the actual dispute and the facts when the dispute has come to light. You mentioned something on the rights and obligations and the use of those two terms. I believe, and this would be applied to common law, when you talk about rights and obligations, for every right, there's a corresponding obligation. So when you are bringing up a dispute, you are talking about that someone or a party not fulfilling the obligation, which then infringes on another's rights. So in that context, the text is actually rightfully placed. One other thing, okay, the issue of the good office mediation, conciliation, I think those are just part of ADR in terms of trying to resolve the matter before it gets to now, can you call it a full-blown dispute? And I think that is a common practice amongst all our countries, to try and resolve the matter out of court, so to speak, before you can now make it a full-blown dispute. And then, of course, definitions. You define items, I think as the judge earlier said, you define words that have not been used in their normal the day-to-day use. So, and I think it's in common parlance, in the nomenclature of dispute settlement, even under WTO, good office, mediation, conciliation are used in that particular manner. So there was no need to now again go and define what those are. You have mentioned quite a critical aspect of electronic filing of documents. It is a critical issue, but what would happen was, I think many African countries are still struggling with connectivity issues, which was a challenge, and that is what was raised on the floor. So I think it's something that is going to be considered moving forward, even as we try to implement this protocol. For private actors, I think one school of thought would be private actors are not parties to this instrument, and usually the rights, I mean, whatever rights are being infringed, it's a measure that has been taken, that has been implemented by, I mean, put in place by a state party. Jurisprudence, indeed, will have to start somewhere. Our jurisprudence is not there yet. Even the WTO started somewhere. So at one point or another, one country will have to file a matter in this to get used to use this system. So in general, I think my hope is that the Institute will help in terms of compiling some of the issues that have been raised here to submit to the Secretariat to make this and other protocols better for use for the benefit of the continent. I think I'll stop there. Thank you.
we seem very well connected with the true deciders, with the makers of the system. So please ask them to make issues more transparent. So we are aware of meeting. I am not aware from the meeting. I am not within the system. I am outside the system. So please ask them to make them available on the website. Hopefully, hope that connectivity will be good and we can get the information, because as you said, we have a problem of connectivity and internet. So at least ask them to make them available on the internet and on paper and send them to the different countries to know that. I will be happy to be aware of what's happening. And we should agree that the website is not so good as the African Union. They have a good website. So I don't understand why the Secretariat is not, they don't have the same website or the same services. To finish, I was here not in conflict with any of you. I am a very peaceful man, and I try to give you a position, a personal position that could be good and could be bad. It was a pleasure to exchange with all of you. It was very interesting to get this fruitful debate. Thank you so much, and I hope that you will spend a good lunch, and I will stay here with you. I will be happy to discuss with you, but not on this issue, dispute settlement. If you discuss on this issue, we will have a personal dispute settlement that I want to avoid. Thank you so much. It was a pleasure, and see you in other occasion and event. Thank you so much.